Well, Laura and David, why don't we jump into this? We'll get through introductions and maximize the amount of time that we can actually talk on the meat of our subject matter here. So allow me to first welcome everyone to our event today on academic freedom, the First Amendment in the American University. My name is Stephen Collis. I'm the faculty director of the Bech-Loughlin First Amendment Center here at the University of Texas School of Law. And we have a very exciting conversation today with David Rabban and Laura Weinrib, whom I'll introduce more fully in just a moment, trying to maximize my opportunity to make them uncomfortable. First, David and Laura, welcome, and thanks so much for doing this. Just so thrilled to have you here. A few housekeeping items before we move to introductions. David's going to present some of his latest research related to academic freedom and First Amendment at American universities. Laura will get some time to respond, and then we'll open things up for a more free-flowing conversation. I encourage everyone in the audience to go ahead and put their questions in the Q&A as they come to you, as David and Laura are speaking. I'll monitor those, and then when we get to the more free-flowing part of the conversation, we'll try to get to as many as time allows and hopefully get them addressed. So with that, let me jump into introductions. David Rabban is the Jamail Regents Chair, University Distinguished Teaching Professor at the University of Texas School of Law. He joined the Texas faculty in 1983 after serving as counsel to the American Association of University Professors. He also served as general counsel of the AAUP from 1998 to 2006 and chair of its Committee on Academic Freedom and Tenure from 2006 to 2012. He is one of the leading scholars in the country on free speech, higher education, and the law, and American legal history. He's best known for his path-breaking work on free speech in American history. He's the author of many acclaimed books, and his many articles have appeared in the Yale Law Journal, Stanford Law Review, the University of Chicago Law Review, and elsewhere. He was a fellow of the John Simon Guggenheim Foundation in 2016 and of the program in law and public affairs at Princeton University. His most recent published book is Law's History, American Legal Thought and the Transatlantic Turn to History. David, so grateful you're here.
Nice to be here.
Laura Weinrib is the Fred N. Fishman Professor of Constitutional Law at Harvard Law School and the Suzanne Young Murray Professor at the Radcliffe Institute for Advanced Study. A legal historian, she studies how social movements have transformed constitutional categories to pursue political and economic change. She is the author of the book, The Taming of Free Speech, America's Civil Liberties Compromise from Harvard University Press, which traces the emergence during the first half of the 20th century of a constitutional and court-centered concept of civil liberties as a defining feature of American democracy. Her articles, essays, and book chapters have explored a wide range of subjects in American legal history, as well as constitutional law, labor law, and law and literature. She holds a law degree from Harvard Law School and a PhD in history from Princeton University. And before joining the Harvard Law School faculty in 2019, she was professor of law at the University of Chicago Law School and an associate member of the University of Chicago Department of History. Laura, thank you so much for being here. This is a wonderful opportunity. And with that, David, I will turn it over to you. We're looking forward to hearing your latest.
Okay, thank you, Steve. Thank you, all of you on Zoom, for joining us. In my opening remarks, I want to focus on the meaning of academic freedom as a First Amendment right. As I'll discuss, the courts have clearly recognized this right, but its meaning and its relationship to other First Amendment rights remain uncertain. As a preliminary matter, it is important to remember that the First Amendment only applies to action by the state. State action abridging academic freedom can come from legislative and executive branches of government and from public universities themselves. But the actions of private universities are outside the purview of the First Amendment. So First Amendment academic freedom applies to legislative and executive actions that affect professors and universities, and to disputes between professors and administrators or trustees at public universities. But academic freedom as a First Amendment right does not apply to disputes within private universities. So the identification of academic freedom as a First Amendment right first arose in a series of Supreme Court cases brought by professors in the 1950s and 60s, challenging government investigations and legislation justified as efforts to prevent subversive activity by people sympathetic to the Soviet Union during the Cold War. In Sweezy versus New Hampshire, the 1957 case in which the Supreme Court initially recognized academic freedom as a First Amendment right of professors, in that case, the plurality opinion differentiated academic freedom from political expression, while maintaining that the First Amendment protects both. In Kiishian versus Board of Regents a decade later, the Supreme Court specifically identified academic freedom as, quote, a special concern of the First Amendment, unquote, a phrase that has been frequently quoted in subsequent decisions. Yet in neither Sweezy nor Kiishian did the Supreme Court rely on First Amendment academic freedom as the basis for the decision. Subsequent Supreme Court opinions have similarly identified academic freedom as a First Amendment right of professors without relying on it. Yet many lower court decisions have invoked First Amendment academic freedom as the doctrinal basis for their decisions. I just want to give a couple of examples. In one case, a professor teaching a class called, quote unquote, language and social constructivism asked students to suggest words used in the interest of the dominant culture to marginalize minorities and other oppressed social groups. Students suggested epithets that insulted homosexuals, Blacks, and women. Concluding that the First Amendment right of academic freedom protects the professor, the judge emphasized that the words elicited were, quote unquote, germane to the subject matter of the class and were not used in a gratuitously abusive manner. Other cases applied First Amendment academic freedom to protect a professor's disagreement with the university president about the value of an exchange program with the Soviet Union, and a professor who criticized the Board of Regents for sponsoring an ethnic studies program at the university, which the professor called, quote unquote, incredibly mediocre. One case applied First Amendment academic freedom to prevent covert police surveillance of a class, and there are many cases that have applied First Amendment academic freedom to protect professors against the forced disclosure of unpublished research data. Now, since the 1960s, the Supreme Court has developed what Justice Kennedy has called, quote unquote, employee speech jurisprudence. And employee speech jurisprudence applies the First Amendment to distinctive issues posed by the speech of public employees. Employee speech jurisprudence is both more specific than First Amendment law, which covers all citizens, general First Amendment law, and employee speech jurisprudence is less specific than the First Amendment right of academic freedom, which covers the small proportion of public employees who are professors at public universities. Now, the Supreme Court itself has not applied its employee speech jurisprudence in cases arising at state universities, but many lower courts have applied employee speech jurisprudence to the academic speech of professors, often in contexts in which other courts relied on instead on the First Amendment right of academic freedom. And applying employee speech jurisprudence rather than First Amendment academic freedom to the academic speech of professors has often produced different results. Based on the doctrine that speech by public employees must be about matters of public concern to qualify for First Amendment protection, courts have concluded that lots of academic speech that would be protected by First Amendment academic freedom does not address public concerns. Courts using employee speech jurisprudence have excluded from First Amendment protection, quote unquote, abstract theorizing by professors that does not interest the general public. A professor's criticism of the dean, another decision observed, was quote unquote to make the university better, not to address a matter of public concern. And based on the doctrine that the First Amendment does not protect speech by public employees pursuant to their official duties, some lower court decisions have concluded that classroom speech and scholarship of professors are unprotected official duties. Back to First Amendment academic freedom, beginning in the 1970s, the Supreme Court extended the First Amendment protection of academic freedom beyond professors to universities as institutions. Justice Powell's dispositive opinion in Bech-Loughlin, the famous 1978 affirmative action case, was the first time a Supreme Court justice explicitly applied the First Amendment right of academic freedom to an institutional decision made by a university. Powell maintained that the First Amendment academic freedom of a university includes the use of affirmative action to create a diverse student body that contributes to the education of all students. Powell only wrote for himself in Bech-Loughlin, but 25 years later, the Supreme Court majority endorsed this approach. The Supreme Court has also applied institutional academic freedom to uphold a faculty decision to dismiss a student on academic grounds. Yet, as courts often concede, decisions have really never provided much analysis of the meaning of either individual or institutional academic freedom, or the relationship between academic freedom and other First Amendment rights. So I now want to try to do that in a few brief minutes. To me, a convincing theory of First Amendment academic freedom must differentiate academic freedom from general First Amendment rights of free speech, while explaining why academic freedom fits within the First Amendment. If academic freedom is the same thing as free speech, there's no need for a special theory of academic freedom. Yet if academic freedom is different from free speech, its distinctive meaning must be connected to the First Amendment. In my opinion, the social value of the contribution to knowledge through the expert academic speech of professors provides the primary basis both for differentiating academic freedom from general rights of free speech and for connecting academic freedom to the First Amendment. The distinctive meaning of academic freedom as protecting expert academic speech is connected to the First Amendment because Supreme Court decisions in numerous contexts have recognized the production and dissemination of knowledge as a fundamental First Amendment value. Now, justifications for academic freedom for professors apply most persuasively to their core activities of scholarship and teaching. It just doesn't make sense to expect professors to share their expert academic knowledge in scholarship and teaching, yet to allow them to be punished for doing so. But in addition to specialized knowledge within their academic disciplines, professors have more general expertise in matters of educational policy that influence the production and dissemination of knowledge. And I think it is plausible to extend First Amendment academic freedom to this general expertise. On the other hand, and I want to emphasize this justification for academic freedom does not extend to speech by professors unrelated to their expertise, whether about the university or about external political issues. This non-expert speech of professors should be governed by general principles of free speech and employee speech jurisprudence, not by academic freedom. I also think it's plausible to extend First Amendment academic freedom to the university, especially its institutional autonomy in making educational decisions. Special legal rules associated with academic freedom can foster the distinctive ways that educational decisions made on behalf of universities contribute to the production and dissemination of knowledge, just as they foster the distinctive way that the expert academic speech of professors contributes to this important First Amendment value. Yet just as the academic freedom of professors does not extend to their speech unrelated to expertise, institutional academic freedom should not extend beyond the educational decisions of universities. And I think there are quite a number of university decisions that are based on institutional commitments to social rather than educational values, such as denying recruitment facilities on campus to organizations whose employment or environmental policies contradict standards established by the university. These decisions, to me, are outside the scope of institutional academic freedom, though they may be covered by general First Amendment protections for institutional autonomy. So an affirmative action plan justified by the educational value of diversity would fit within institutional academic freedom. But an affirmative action plan justified by the social value of a more integrated or economically mobile society would not fall within institutional academic freedom, I believe. I also want just to spend a couple of minutes making the argument that universities should have institutional academic freedom to regulate some offensive speech on campus that interferes with the educational process, even if that speech would be protected in the public sphere by the general First Amendment right of free speech. And I want to take examples from my own campus, the University of Texas at Austin, to illustrate this point based on journalistic accounts of incidents that occurred in the spring 2017 semester. So during the spring 2017 semesters, flyers were distributed on campus that stated, quote, "Imagine a Muslim-free America," unquote. Another titled, quote, "Ethical Lessons to Chinese," unquote, claimed that in Chinese culture, it isn't bad to steal another's work or to lie on job applications, and described a fake course in ethics to teach integrity to Chinese students. After a Black male student was taken into custody following a stabbing incident on campus that led to the death of another student, flyers depicted a caricature of a Black man holding a knife alongside the words, quote, "Around Blacks never relax," unquote. In my opinion, even if the First Amendment prevents the city of Austin from confiscating or punishing these flyers if distributed on a public sidewalk, I think the University of Texas should be able to do so under the protection of First Amendment academic freedom. A university could legitimately conclude that these flyers would undermine the learning environment for Muslim, Chinese, and Black students, and perhaps for other students as well. Although universities should be able to discipline some offensive speech that would be protected in the public sphere, in my view, institutional academic freedom should not encompass the right of a university to regulate expression about the content of ideas. Exposure to ideas, including ones that may be offensive, so offensive that it may make it harder for some students to learn. Still, exposure to ideas is a fundamental part of the educational process. I therefore agree with the judge who held that the university could not discipline the professor who asked students to suggest words that marginalize minorities, even though those suggestions included epithets against homosexuals, Blacks, and women. Based on the facts of other cases, I believe that institutional academic freedom does not allow a university to deny tenure to a professor because it objects to his course treating Zionism, like Nazism and apartheid, as a form of racism, or to discipline a professor because his course on comparative animal behavior includes theories maintaining that males are better than females at certain mental tasks involving spatial relationships. Finally, I want to point out that institutional academic freedom complicates questions about who has authority to exercise academic freedom on behalf of the university, and the extent to which private universities might have more institutional academic freedom from the state than public universities. For me, on some issues, such as appointment and tenure, faculty should have the primary authority to act on behalf of the university. But on others, such as policies regulating affirmative action or student extracurricular activities or determining access to campus by the general public, to me, and for those matters, trustees and administrators should have primary authority. Also, while both state and private universities should have institutional academic freedom to determine whether evolution or creation science are legitimate academic theories, I think a state university could require a state legislature, I think, could require a state university, but not a private one, to teach courses in American history, as I believe Texas so requires. Finally, I want to point out that claims of academic freedom frequently conflict with state interests such as national security, public safety, and the enforcement of general laws regulating subjects such as labor and access to public records, and with individual interests in free speech, freedom of religion, and freedom from employment discrimination are individual interests that could conflict with academic freedom. So I don't have time to discuss these conflicts now or how they might be resolved, but I'd be happy to address them during our discussion. And so thank you for your attention, and I look forward now to hearing Laura's remarks and to your questions and comments later on. Thanks very much.
Thank you so much, David. That was wonderful. I know you were asked to take 600 pages of work and years of research, probably thousands of pages of work, and reduce it down to 15 to 20 minutes. We really appreciate it, and the insights were very valuable. Laura, I'll turn it over to you.
Great. Well, thank you. It's a pleasure to be here today, engaging with David on the issue of academic freedom. As Steve just alluded to, David's remarks today are just the tip of the iceberg. They grow out of his new book, which I've had the pleasure of reading. And I want to start by saying that the book is an incredible achievement. Exhaustive research, the theory is illuminating, and I think the practical recommendations are persuasive and promise to shape the debate about academic freedom going forward. David has managed to capture what's distinctive about academic freedom as compared with speech regulation in other institutions, public and private. And for the most part, I'm persuaded by his conclusions about how the various kinds of disputes he describes should be resolved. Now, to be sure, I may disagree in particular cases, and I have questions about particular conclusions, and I suspect many of you share some of those questions, and I hope you'll ask them, and David will have a chance to answer them in the Q&A. But I regard my differences from David on these issues as relatively minor. So on the whole, I agree with David that the principles that animate other strands of First Amendment law, like public employee speech doctrine, are inadequate and often antagonistic to the principles of academic freedom. And I also agree that academic freedom should not extend to content that fails to meet academic standards as defined by faculty peers, even if I understand, as David does, that field-changing ideas are often initially rejected or misunderstood. Okay, so all that said, if the goal of the academic enterprise is to develop ideas through rigorous intellectual debate, I had better find a point on which to interrogate David's account. And I find myself most inclined to push back on David's most ambitious claim, namely that the best way to implement his vision of academic freedom is to constitutionalize it and to inscribe it in the First Amendment so that courts can better balance the competing interests at stake. So because I'm a historian, and I want to begin, as David does in his book, with the history. But I want to look at the origin story he offers through a slightly different lens. And by doing so, I want to invite him to consider the theoretical and institutional concerns that may have animated early activists and that may have renewed relevance, I want to suggest today. David's book opens about 100 years ago with the early statements on academic freedom by the American Association of University Professors, or AAUP. The AAUP's 1915 Declaration of Principles on Academic Freedom, along with its subsequent statements, guide David's analysis of First Amendment academic freedom throughout the book. But as David notes, the AAUP did not intend for its vision of academic freedom to be channeled through the First Amendment, nor did it intend for it to be enforced by the courts. David assumes that the AAUP's late entry into constitutional litigation over academic freedom as a First Amendment right owed to its reservations about judicial competence to assess scholarly expertise. And so he devotes a lot of space in the book to explaining how and when judges could satisfactorily resolve disputes about academic standards. And I should say he relies here on a heavy dose of deference to peer review. But it's not clear to me that the AAUP's principal concern with constitutionalizing academic freedom and inviting additional judicial intervention was really about competence. Maybe David comes closer when he notes that the AAUP's concerns that courts would misinterpret academic freedom, and he said preempt its interpretation within the academic community. So this is sort of an argument about a turf war, but I suspect even a concern about displacement or usurpation of academic autonomy is not the whole story. So the question is, of course, why did the AAUP initially spurn the constitutionalization of academic freedom? And my view is that their early opposition stemmed from a deep suspicion of judicial power, and in particular, the formalistic and individualistic tendencies of the judiciary in construing constitutional rights. Their antagonism to judicial enforcement of constitutional rights wasn't just an oversight to be corrected. It was core to their vision of academic freedom in ways that I think have lasting implications today. So to get at why, I actually want to back up another century, as David does in his second chapter, and consider briefly the 19th century forerunners of today's First Amendment academic freedom cases. And David tells us that the courts policed the relative power of legislatures and trustees during the early 19th century through the impairment of contracts clause. Courts would ask whether state legislation unduly restricted the governing board of the university and thereby violated its charter, which would render it an impairment of contract. And then after passage of the 14th Amendment, the courts turned instead to their expansive interpretations of liberty and property rights, what's typically called substantive due process. And on this theory, abridging the right to teach interfered with the liberty and property rights of instructors and potentially the liberty interests of students as well. Okay, so those of you who are familiar with the history of the Lochner era will not be surprised to hear that the progressive pioneers of academic freedom did not embrace this approach. In Lochner v. New York, the 1905 case for which the Lochner era is named, the Supreme Court famously invalidated a maximum hours law for bakers on the ground that it infringed their liberty of contract. And it was through substantive due process, through this expansive interpretation of liberty and property rights, that the courts invalidated the most important social and economic reforms of the late 19th and early 20th centuries, including workplace safety and workers' compensation laws, the minimum wage, and progressive taxation. Okay, now the AAUP's protection of academic freedom was a thoroughly progressive project in the historical sense of that term. Early 20th century progressivism imagined a unified public welfare, and they trusted in expert administrators to promote it. The AAUP's understanding of academic freedom fit neatly within that broader framework. It assumed that academic knowledge was capable of objective assessment and that it was properly evaluated by peers within a scholar's discipline rather than by lay trustees who were motivated by politics and ideology. The principles of academic freedom were to be enforced through self-regulation by convening bodies of fellow academics within and across universities. And the state, and I want to emphasize this, was seen not as an obstacle, but as a crucial ally in this endeavor. So when Charles Beard resigned from Columbia over what he described as the suppression of free speech by reactionary trustees with no academic training, he offered a characteristically progressive solution. He said, I am sure that when the people understand the true state of affairs in our universities, they will speedily enact legislation which will strip boards of trustees of their absolute power over the intellectual life of the institutions under their management. Okay, so from the beginning then, the AAUP's statements on academic freedom sounded in a classic progressive register. They advanced academic freedom as a mechanism for promoting the common good. The 1940 statement opens with the premise that, quote, institutions of higher education are conducted for the common good and not to further the interests of either the individual teacher or the institution as a whole. So given this focus, the AAUP could not have imagined an institution more poorly suited to advancement of its goals than the judiciary. From Roscoe Pound to Zechariah Chafee to John Dewey and Alexander Meiklejohn, the seminal progressive theorists of free speech agonized over judicial enforcement of the First Amendment. During World War I, Chafee famously promoted a vision of free speech premised on what he called the social interest in the attainment of truth. But even he was ambivalent about entrusting it to the courts as opposed to Congress. Nor did views on this issue change significantly between the AAUP's initial declaration in 1915 and its 1940 revision. So as Dewey put it in a 1936 essay, the dominant philosophy of the Bill of Rights had sprung from fear of government and of organized control on the grounds of their supposed inherent antagonism to the liberties of individuals. And he rejected the court's, as he put it, individualistic and laissez-faire conception of civil liberties, which treated regulations of speech as equivalent to regulations of the economy, as contests between political power and individual liberty. He thought of free speech as necessary scaffolding for state power, not as a mechanism for opposing it. Now, of course, that's not to say that there were no advocates of a strong judicially enforceable First Amendment during the 1920s. There was one in particular, the newly formed American Civil Liberties Union. I can't go into the early history of the ACLU here, so you're going to have to take my word for it when I tell you that when it was founded in 1920, the ACLU saw itself as an adjunct of the radical labor movement in the United States. Although the organization often worked with progressives, it was far more skeptical than they were of state power. And that skepticism grew out of the state suppression of strikes and boycotts. Over the course of the 1920s and 30s, they litigated the major cases that produced our modern First Amendment with its exceptionally strong protections against state regulation of speech. And despite their own initial distrust of the judiciary, they ultimately teamed up with conservatives to reimagine the courts as a check on state power, with the hope that the courts would protect a First Amendment right to engage in, as it turns out, mass picketing and secondary boycotts that they thought would transform American political and economic structure without bloodshed. Now, needless to say, the ACLU's early goals were never realized. Its early gains in protecting a right to engage in labor picketing were basically shut down by the 1940s. And the trouble was that the courts very quickly reinterpreted the First Amendment as a liberal constraint on state overreach. This was a vision that was incompatible with the labor activity the ACLU wanted to protect. In fact, the story played out almost exactly as the ACLU's progressive critics said it would. But that's a story for another day. What I want to emphasize for today's purposes is that the ACLU declared in the mid-1920s that education was its new battlefield. And its first committee, which was formed in 1924, was its Committee on Academic Freedom. And it partnered with the AAUP on some cases, especially cases involving extramural political speech. That's an issue that the AAUP regarded as secondary, and as you heard, David excludes from the terrain of academic freedom. So there's a lot to say about this juncture, but for now, I just want to emphasize that the ACLU, in contrast to the AAUP, was willing to turn to the courts for enforcement of academic freedom. So I'll give you just one example to illustrate this point. Some of you may be familiar with a 1925 Supreme Court case called Piersky Society of Sisters, in which the court struck down Oregon's compulsory public school law. And as you may know, that law, which would have eliminated parochial schools in Oregon, was motivated in large part by anti-Catholicism, and it was endorsed by the KKK. But it was also endorsed by progressive reformers. And they were motivated by very different factors. They hoped that the law would raise the quality of the public school system and mitigate class differences in education. And they fought hard to keep this dispute out of the courts. Now, notably, the ACLU was on the other side, and publicly it emphasized religious freedom and parental rights. But the explanation it offered in private correspondence, and I think this goes to the heart of the matter, is illuminating. So the ACLU's executive director wrote to one of the Oregon progressives who were involved in this, said, we've got a number of experimental private schools in and near New York, which are infinitely more valuable to the future of education than anything that the public schools are doing. Under such a law as you have in Oregon, they would be wiped out. And what he was referring to was the Rand School of Social Science. This was a school for adult workers that was likened at the time to a seminary for socialism. And the purpose of the Rand School was to groom labor leaders for political advocacy and successful strikes. New York was in the midst of trying to shut it down. And notably, when the Rand School defended its right to operate in court, a socialist leader and labor lawyer who was a member of the ACLU's National Committee argued the case. And one of his central contentions was a claim about the constitutional limits of state regulatory power. What he said was that New York's licensing requirement trampled the Rand School's right to liberty and property under the Due Process Clause of the 14th Amendment, along with the First Amendment. And the irony was apparent to observers. Zechariah Chafee, the progressive theorist I mentioned a few minutes ago, mused that classrooms of the Rand School must have frequently echoed to denunciations of Lochner and other notorious examples of judicial review. But now the Rand School was citing these very cases to extend constitutional protection to its own unpopular activities. Okay. One more point here. The ACLU was willing to make use of judicial anti-statism because it believed that radical education, if it were only sheltered from state suppression, had the potential to awaken the masses. its goal was expressly to secure radical propaganda. That's the term they use. It was a term that had not yet acquired its negative connotation and which the ACLU embraced. Now, whatever one may think of that purpose, it was decidedly not about a commitment to the production of knowledge or to the societal value of academic expertise, which are the values that the AAUP and David tells us academic freedom should be about. So where does all this history leave us with respect to David's project for today? Let me start by reiterating that David's vision of academic freedom is premised on the AAUPs, not the ACLUs. Outside the confines of the university, he's largely sympathetic to our strongly anti-statist First Amendment regime. But on campus, what he envisions is an alternative set of First Amendment values oriented to the search for truth through the expert production of knowledge. And in fact, it's hard to imagine how a radically anti-statist conception of the First Amendment could ever really be reconcilable with a commitment to public education. Needless to say, some of our nation's most influential and prestigious universities, including this one, where David has taught for almost 40 years, are funded and operated by the states. And I think that reflects at baseline an enormous amount of trust in state power. Now, of course, to say that we regard the state as a source of regulation and of knowledge production in the public interest, rather than merely a threat to private interests and individual rights, is not to say that we reject all limits on state authority, nor is it to presume that legislators, rather than the academic experts employed by the state, should be empowered to dictate the curriculum or particular decisions about tenure and discipline. And David, I want to emphasize, is very thoughtful about the ways the lines should be drawn, about the hard work of balancing in particular cases, and about who should be making decisions about the sort of scholarship and debate that advances public knowledge and cultivates the intellectual development of our students. He urges courts to defer to faculty bodies on a wide range of issues. David is also well aware of the AAUP's reluctance to constitutionalize academic freedom. He notes that the AAUP worried about judicial appropriation of a concept that properly belonged to the academic community, and that it worried that, quote, even a favorable legal definition of academic freedom would be subject to further judicial interpretation. David says, what the court might give, many within the AAUP feared it might also take away. But when push comes to shove, David rejects those concerns as short-sighted and counterproductive. He tells us that First Amendment litigation provides greater opportunity for remedying violations of academic freedom than the AAUP model does, that the AAUP can only pursue a small slice of the complaints it receives, but the courts are open to all, and judges can award remedies like back pay and reinstatement. So I know I'm running short on time here, but I'll wrap up by saying, from my perspective, there's something very appealing about the First Amendment right David suggests. Rather than privileging merely formal rights against state interference, it acknowledges that regulation can actually improve the quality of discussion, and that the exercise of professional judgment to elevate particular views may be necessary to effectuate meaningful progress. I embrace David's view that academic freedom, in contrast to the general First Amendment right to free speech, should be understood, as he puts it, as communitarian rather than individualistic. In fact, unlike David, I'm open to exporting the values he reserves for academic freedom into the broader public sphere. But given this orientation, here's the problem I want to put to David. The reality is that the Supreme Court has not proven sympathetic to such rights. On the contrary, wherever attempts have been made to define rights in this way, the court has swung the other way. So there's lots of talk now about the Lochnerization of the First Amendment, of the use of the First Amendment to achieve deregulation and to undermine state power. and that critique is likely only to intensify, I think, in the coming years. The court has essentially collapsed First Amendment rights and the rights of private property, invoking them to invalidate such progressive era innovations as right of reply statutes, campaign finance regulations, or this past term, laws requiring access to property by union organizers for the purposes of communicating with workers. Now, David suggests that academic freedom need not be advanced exclusively through judicial enforcement of the First Amendment. He says advocates could also look to legislation and collective bargaining. But the trouble is that such efforts would likely run afoul of the formalistic interpretation of judicial enforcement of academic freedom that I anticipate. So just one more example, and then I'll stop. That conflict comes across most clearly, I think, when we look not to cases involving loyalty oaths or curricular control, but to unions. David discusses Minnesota State Board of Community Colleges v. Knight, which is a 1984 Supreme Court decision in which Justice O'Connor wrote for a majority denying the First Amendment speech and association claims of non-union professors who were excluded from institutional policymaking decisions. And David is sympathetic to the dissent's view in that case. Well, it turns out he's not alone. The arguments that lost out in Minnesota State Board for Community Colleges v. Knight are now being resurrected to argue that union representation in colleges is unconstitutional. And more broadly, the same arguments are being used to suggest that exclusive representation in all public sector unions is a per se violation of the First Amendment. And needless to say, I think private sector unions are next. So to be fair, David is not writing in a First Amendment vacuum. The alternative to judicial enforcement of academic freedom is not, as it was in the 1910s, self-regulation by academic experts, shielded perhaps by state legislation limiting the influence of trustees. Rather, the alternative is a morass of conflicting decisions applying generally applicable First Amendment doctrine in ways that often undercut academic freedom. And David, I think, is motivated by a desire to bring clarity to the very messy case law, and also, I suspect, by the assumption that judicial encroachment is inevitable and that constitutional interpretation would be better if it took the distinctive needs of the university into account. So I think those are laudable goals. Nonetheless, to the extent David is inviting litigation and judicial intervention into domains that are currently relatively insulated from constitutional oversight, I can't help worrying that the cure is worse than the disease. With that, I am eager to hear from all of you and from David.
Thank you, Laura. And David, I'd love to give you some time for a quick response. We also have at least one question in the Q&A. If there's time, I have a question for you. I think other questions might come as well, but I think it's only fair if you'd like to have a quick exchange back with Laura on some of her comments.
Well, I'd like to thank Laura for her very interesting and largely plausible to me comments. I can talk to Laura later, and I know time is running out. So maybe for now, we should hear from people in the audience.
Sure. So we have one question pending, and they asked you, David, really, what's the principle that determines whether a question should be decided by the faculty or the administration? For example, you say the administration should make affirmative action admissions decisions. Why is it not the faculty's role to decide the value of diversity and who should be admitted?
Yes, it's very complicated to assess like who should have responsibility in a university. Laura is right. I rely heavily on AAUP documents for my constitutional interpretation, not because I think those documents have constitutional meaning, but because I think they inform First Amendment principles. Universities are marked, good universities, by shared authority. And I do think there are certain issues, and the AAUP acknowledges it, where university administrators and trustees have made responsibility, though they should consult with faculty. For me, like broader educational policies like affirmative action fall within administrative and trustee responsibility. Faculty should be involved, but to me, the ultimate decision should be by administrators. The core faculty expertise is with respect to their disciplines, right? Scholarship, teaching, whether having a new program makes educational sense, but broader educational issues like affirmative action. I think the faculty should be involved, but I'm willing to cede that to the administration.
Laura, does that strike you as a plausible line, trying to decide between administration and faculty? You're muted right now, Laura. The curse of Zoom.
Sorry. Yeah, I mean, so these are the tough line drawing problems that I think are going to inevitably come into all of these decisions. And, David, I mean, the short answer to your question is yes, I think that's probably plausible. I feel like, it's going to be hard in, I think a lot of these cases in my mind are going to come down to factually specific questions that vary case by case. And that's one of the reasons that I feel like courts are less well suited than an independent expert body to decide. And so I'm generally sympathetic, but I worry about the hard cases, I guess I would say.
Great. Well, let me pivot and ask you both a separate question. You both mentioned this kind of in passing. Laura, you said you thought you agreed with David, and it's this concept of using peer review as a mechanism for determining kind of policing, I suppose, right, academic freedom. And David, you mentioned in the book and in your manuscript something that you call the paradox of peer review. And that something about that struck me as somewhat problematic. It seems to have no endpoint in my view. So there's many fields of inquiry could be shut down simply because those in a given field have determined what is orthodox. You seem to argue at one point, I think, that once a field has determined what is orthodox, they can then shut someone's inquiries or thinking down, and that wouldn't be seen as a violation of academic freedom. Simply this person wouldn't be, complying with the academic norms in their field. But that seems to prove too much. It seems to block off all sorts of inquiry and also seems to completely contradict the notion that the purpose of academic freedom, at least one purpose, is to challenge current understanding. So I think it makes perfect sense to have peer review in the sense that you're challenging people on their methodology, use of evidence, empirical studies, things like that. But the conclusions people draw that might run against the orthodoxy of an entire field seems like that should be allowed. And I worry about that paradox that you talked about. I'd love to hear your thoughts on that.
It is a paradox. I would say 2 cheers for peer review, like Winston Churchill said, 2 cheers for democracy. It has problems, but it's hard to imagine a better alternative. Who's to determine whether ideas meet academic standards? Yes, professors sometimes may be kind of too orthodox in determining what are good ideas. But most professors, I believe, they're open to new ideas. It takes time, but new ideas have managed to prevail in the academic world. Not always, but often. And I think professors are mostly committed to having a diversity of views. That's almost why they become professors. They believe in that. So who would you rather have, Steve, determining whether a school has become too orthodox? The Texas legislature? Justice Scalia, who wanted to allow a legislature to force a university to teach creation science? I'd rather leave those decisions up to peer review, subject to administrative overturning if the peers cannot establish convincing reasons for their decisions. No one other than faculty experts are really in a position to determine the value of academic speech.
So I agree with, so I don't, my dispute is not with peer review, it's more the worry about the paradox. And I guess what I'm wondering is, why can't the line simply be drawn on a focus on methodology, not necessarily on the orthodox or heterodox nature of someone's views that they reach?
Would you appoint someone who believes the earth is flat?
Well, again, I guess I'm struggling to find someone who would argue that the Earth is flat, who would come in with a methodology that would be plausible. So I guess I'm just wondering how you would draw the line. But let's let Laura jump in on this.
Okay.
Well, I mean, I'd love to follow up on this because I think actually often the methodology is precisely what's subject to dispute. So I'm not sure that solves the problem. In fact, a lot of the examples David gives in the book turn precisely on this. And David gives good examples of new and revolutionary methodologies being shut down, which I think is a problem, and it's the source of the paradox. But I also agree with, well, I shouldn't say shut down within the academy. I think the mechanism that he sort of leaves open as a possibility is that it can grow outside of elite universities. This is not suppression of the ideas, it's just failure to award tenure on the basis of them. But I think, and so, they can be pursued elsewhere. Of course, it's going to have the effect, though, of reinforcing the status quo within the discipline over time. But I think the basic who decides question that David makes is the hard one here, as it is, frankly, in many, many free speech cases. The what's the alternative question carries a lot of the weight.
That's why it's a paradox, I would say, Steve. It's hard for just that reason. But bottom line, I would trust peer review over alternatives.
I agree with that. I also look forward to the discovery of the solution to the paradox. So let me ask one more question here that's popped up in the Q&A. It says, David, an example you posed in your statement was when derogatory articles or posters had been posted around the university, the city of Austin did not have the right to remove them, but the University of Texas should have that right. What, if not the First Amendment, regulates what the university is allowed to remove? Is this not the same debate regarding is hate speech free speech? I guess to clarify, how is the line set for how the university can determine what is dangerous?
Yes, and I would say if the university is making its determination on educational grounds that allowing this kind of hate speech undermines its educational function, that gives the university, in my view, authority to make those decisions that the city of Austin doesn't have under general First Amendment law. And that's why I tie First Amendment academic freedom to the educational decisions of universities. I hope that's if that's not responsive to the person who asked the question, I'd invite further inquiry.
Well, they're anonymous, but hopefully they can type in.
Okay. Yeah.
Laura, do you have a response to that? And how do you feel about that line David's tried to draw there?
I think this is a tough one. I mean, I have a question for David of my own on this front, which basically turns on, I've just lost my, give me one moment here. Steve, did you want to?
All we have is one moment, so hopefully it comes back to you very quickly. We're almost out of time.
Okay, well, so I'll let it go. Basically, I think this is a difficult line to make, and the question is defer. So I'm so sorry, I totally lost my train of thought here. David, can you just repeat very briefly what you were saying?
Me? If the university bases its decision on educational grounds, I would include it. Okay. Yeah.
So the question is, I mean, you do this in a number of different areas. Isn't this just a matter of framing, and isn't any savvy university going to say going forward that it's basing its decisions on educational grounds? And then where is the stopping point?
Yeah, I had that same question. How are you going to draw that line? How are you going to police that?
Well, ultimately, I know this is not the answer you want, Laura, but I would have at some point, judges would evaluate it. I would encourage judges, and to me, judges are too deferential to universities. But at some point, it's clearly not an educational decision or not a convincing one. And while deferential, at some point, judges should step in, just as judges should step in when universities claim they're making a decision based on assessment of professional quality, and there's clear evidence it's actually based on employment discrimination or opposition to, political ideology. There is a role for judges there, though limited.
Okay, well, there's other questions I have a list of 10 pages long, probably, David, but well, we're out of time, so we have to stop. What a wonderful conversation. What a wonderful project, David. Thank you for engaging in it and all the heavy lifting you did to bring it to bear. And Laura, you're just wonderful comments and historical perspective. I've really enjoyed it. I wish we had more time, but thank you both for coming, and I hope our attendees enjoyed it as well.
Thank you. Bye-bye.
Thanks. Bye-bye.